Namaskar. I'm Assistant Professor Kritika Dev from LG School of Law, and today we'll be dealing with Indian Evidence Act. And in Indian Evidence Act, we'll be dealing with the specific topic that is privileged communication. Now, when it comes to privileged communication, what do we understand by a privileged communication? And what are the parties or who are the parties who's bound or who are bound by a communication? Let's see with the help of the section. Now, here we will start with section 122 of Indian Evidence Act. Now, what this section says, communication during marriage. So by this we can relate that it is a communication between the two spouses. Now, what happens in it? No person who is or has been married shall be compelled to disclose any communication made to him during marriage by any person to whom he or she has been married, nor shall he be permitted to disclose any such communication unless the person who made it or his representative in interest concerns, except in suits between married person or proceeding in which one married person is prosecuted for any crime committed against the other. So here, the overall point or the nutshell if we discuss, it is about husband and wife, a married couple. Now, if anything is communicated during the marriage, right, when the knot is there, when the marriage is in continuation, and anything has been communicated by the husband to the wife or by the wife to the husband, in any way, then they are not supposed to reveal it. They are not supposed to actually waive this privileged communication. They are not entitled to do so. But of course, in the same section, the exception is also being given. The first one is if the other party, if the other spouse by himself says it, that okay, go on and disclose it. Right? The other party concerns for the same that you are free to disclose it. Then the other party can disclose it. Or if there is a suit between both the parties, right? In a situation where one married couple is prosecuting against the other, for say if there is any divorce proceeding is going on, anything of that sort, when both the parties are against each other, then of course they need to reveal it. Only then they will go through the procedures. Even there, if they hide things, the procedure will not go on. So there they are free from this very privileged communication thing, and they can actually reveal what is there between them or what communications has taken place between the two. So this is about communication during marriage. As we have seen, the conditions are communication during the continuance of marriage. The marriage should be in continuation. The privilege operates only against the spouses, but not the third party. Right? So this is a very important thing. It is a privilege which is there with the spouse only and not with the third party. If the third party has heard something and then reveals the same, then this section will not apply on them and he'll be free. Correct? And privilege does not end after termination of marriage also. So even if the marriage terminates, the communication during that period will not be, it cannot be revealed, right? Because during that period was a communication and will be termed as a privileged communication. Let's see section 123, what it says. It says evidence as to affairs of state. Now, no one shall be permitted to give any evidence derived from unpublished official records relating to any affairs of state except with the permission of the officer at the head of the department concerned, who shall give or withhold such permission as he thinks fit. So here it applies to everybody. It applies to everybody. No one shall. Now, no one is anybody who has received any, any evidence through unpublished official records. If it is published, it is in the public domain, public know about it. But if it is an unpublished public official record and some person has gained any evidence related to it, then he cannot disclose anything related to it. Now, the exception is also given under the same section, except with the permission of the officer at the head of the department concerned. the department from where he has received the information, he need to take the permission of that very head, whether, and now the head who can either allow the person to take that evidence or can withhold it, right? That is section 123. Now let's see what section 124 says. It is the official communication. Now, what do we understand by official communication? No public officer shall be compelled to disclose communication made to him in official confidence when he considers that the public interest would suffer by such disclosure. So here, the first thing is it applies to the public officers, right? It applies to the public officers. And secondly, when secondly, it is made to him in official confidence. Somebody made to him because he is holding that very post, and it was made in that official confidence. And thirdly, he should not reveal that because the in public interest, right, that the public interest would suffer because of that disclosure. So when these 3 points are fulfilled, then that will be known as official communication and the privileged one as well, right? Okay. With this, let's see section 125 of Indian Evidence Act, who is covered under the privileged communication and who cannot be compelled to answer anything related to it. Information as to commission of offences. No magistrate or police officer shall be compelled to say whence he got any information as to the commission of any offence, right? Nor shall any revenue officer shall be compelled to actually give information as to when he has or from whom he has received that very information. So actually when it comes to this very section, it is in order to protect the sources. From there they generally get these kind of, when it comes to police especially, they get the information through certain sources which they cannot reveal. Why? Because it will have a bad impact in future. They might lose that very source. So when it comes to commission of an offense, that yes, you must have seen that police generally receives an information from a source that this offense is taking place. So it is related to the commission of an offense. So when it comes to any information, when it is related to the commission of an offense, they are not compelled to say when they have actually got such an information, right? Because it may lead to other problems in future that would be bad in the public interest, right? So this is about section 125 of the Indian Evidence Act. Now, in the same manner, section 126, that is professional communication, right? It talks about the professional communication. So here, of course, it is between the attorneys and the client, the wakils and the client. It is the professional communication like of that nature. And as we all know, the advocates are not supposed to reveal the communication that they had with the client. But here, of course, there is you can say an exceptional clause, you can say, that let's take an example. For say A says to B that I have committed that very offense, defamation, forgery, whatsoever, you kindly defend me. Now that person is covered under this professional communication privilege. But if that person says, or that I want to commit forgery, kindly help me doing so, then that communication is not protected under this professional communication, because he is actually dragging the professional also into a crime. Defending a party, that is the job of the advocate, but being a part of a crime is not the job of the advocate. So that will not be covered under this very privilege. The next privilege is being mentioned under section 127, that is the interpreters, of course, the extended version you can say. And section 129 talks about communication with the legal advisors. So whatever communication a client is having with the legal advisors, even those communications should not be revealed and they will be covered under the privileged communication. Right? So with this, we have seen what are the privileged communication, and it even happens when it comes to the married couples. Not only in professional lives, till now you must be having the impression that when it comes to privileged communication, it is always between the two professionals, right? Coming to advocates, you must have had the knowledge, but it also applies to a married couple. It also applies when an officer gets the news or information regarding the commission of the crime, then he shall not be compelled to reveal the same, because that was a privileged communication between him and the source, right? So he shall not be actually forced to reveal that very thing, so or compelled to expose that very or when he has got that very information. So with this, I would like to rest my lecture, and I hope everything is clear when it comes to privileged communication. And as I always say, keep reading, keep studying, and keep revising, so that you are in continuous connection with the lectures, and especially with the Indian Evidence Act. Till then, take care and thank you so much.